Okay, this is section 8, the additional terms and conditions. We can write anything we want in here for additional terms. Gives us the ability, basically a whole page, to write anything else that we want in there. The second part of it is, let's kind of go over this stuff. This is the risk of loss. If there's any loss or damage to the premises between the date of contract acceptance and close of escrow or possession, whichever is earlier, by reason of fire, vandalism, flood, earthquake, or act of God, the risk of loss shall be on seller, provided, however, that the cost of repairing such loss or damage would exceed 10% of the purchase price. Either seller or buyer may elect to cancel the contract. Permission. Buyer and seller grant brokers permission to advise the public of this contract. Arizona law. This contract shall be governed by Arizona law, and jurisdiction is exclusively conferred on the state of Arizona. Time is of the essence. The parties acknowledge that time is of the essence in the performance of obligations described herein. Compensation. Seller and buyer acknowledge that brokers shall be compensated for services rendered as previously agreed by separate written agreements, which shall be delivered by the brokers to escrow company for payment at close of escrow, if not paid previously paid. If the seller is obligated to pay brokers, this contract shall constitute an irrevocable assignment of the seller's proceeds at close of escrow. If buyer is obligated to pay brokers, payment shall be collected from buyer as a condition of close of escrow. Commissions payable for the sale, leasing, or management of property are not set by any board or association of realtors or multiple listing service or in any manner other than between broker and client. Copies and counterparts. A fully executed facsimile or electronic copy of this contract shall be treated as original contract. This contract and any other documents required by this contract may be executed by facsimile or other electronic means in any number of counterparts, which shall become effective upon delivery as provided for herein, except that the disclosure of information on lead-based paint and lead-based paint hazards may not be signed in counterpart. All counterparts shall be deemed to constitute one instrument, and each counterpart shall be deemed an original. Days. All references to days in this contract shall be construed as calendar days, and a day shall begin at 12 a.m. and end at 11:59 p.m. Calculating time periods. In computing any time period prescribed or allowed by this contract, the day of the act or event from which the time period begins to run is not included as the last day of the time period, and the last day of the time period is included. Contract acceptance occurs on the date that the signed contract and any incorporated counteroffer is delivered to and received by the appropriate broker. Acts that must be performed 3 days prior to close of escrow must be performed 3 full days prior. For example, if the close of escrow date is on a Friday, the act must be performed by 11:59 on Monday. Entire agreement. This contract and any addenda and attachments shall constitute the entire agreement between seller and buyer, shall supersede any other written or oral agreements between seller and buyer, and can be modified only by a writing signed by buyer and seller. The failure to initial any page of this contract shall not affect the validity or terms of this contract. Subsequent offers. Buyer acknowledges that seller has the right to accept subsequent offers until close of escrow. Seller understands that any subsequent offer accepted by the seller must be a backup offer contingent on the cancellation of this contract. Cancellation. A party who wishes to exercise the right of cancellation as allowed herein may cancel this contract by delivering notice stating the reason for cancellation to the other party or to escrow company. Cancellation shall become effective immediately upon delivery of the cancellation notice. Notice, unless otherwise provided, delivery of all notices and documentation required or permitted hereunder shall be in writing and deemed delivered and received when 1. It's hand delivered. 2. It's sent via facsimile transmission. 3. Sent via electronic mail if email addresses are provided herein. Or 4. Sent by recognized overnight courier service and addressed to buyer as indicated in section 8Q, to seller as indicated in section 9A, and to escrow company as indicated in section 3A. Section 8N, release of brokers. Seller and buyer hereby expressly release, hold harmless, and indemnify brokers in this transaction from any and all liability and responsibility regarding financing, the condition, square footage, lot lines and boundaries, value, rent rolls, environmental problems, sanitation systems, roof, wood infestation, building codes, governmental regulation, insurance, price and terms of the sale, return on investment, or any other matter relating to the value or condition of the premises. The parties understand and agree that the brokers do not provide advice on property as an investment and are not qualified to provide financial, legal, tax, or tax advice regarding this real estate transaction. The terms of acceptance. This offer will become a binding contract when acceptance is signed by seller and a signed copy delivered in person, by mail, facsimile, or electronically, and received by broker named in section 8Q by, and we put a date and a time period in here, AM or PM. This gives us the ability to, to limit how long they're going to hold on to it before they make a decision. It is Mountain Standard Time. Buyer may withdraw this offer at any time prior to the receipt of seller's signed acceptance. If no signed acceptance is received by this time and date, this offer shall be deemed withdrawn and buyer's earnest money shall be returned. This contract contains 10 pages exclusive of any addenda and attachments. Please ensure that you have received and read all 10 pages of this offer, as well as any addenda and attachments. And then we have broker on behalf of buyer. So this is all the information for the buyer's broker. Agency confirmation, broker and named in section 8Q is the agent of the buyer seller. Obviously it's going to be typically buyer here, can occasionally be both buyer and seller. The undersigned agree to purchase the premises on the terms and conditions herein stated and acknowledge receipt of a copy hereof, including the buyer attachment. And then the buyer's information all goes here. If there's 2, it goes here. If we have more, then they can go on another one. Seller's acceptance, we'll just go ahead and do section 9 also, because it's really just the broker for the seller right here, and you check this box seller if they are accepting it or doing a counter offer. So if they're counter offering, then they check this box, and they put the seller's information right here, seller's signature, printed name, and that's everything. That's all the sections.